As I've mentioned more than once, the legal sessions for our village summit and professional development days around the country are always the most heavily prescribed by retirement village managers, because they are on the coalface of having to work with residents, work with the regulations, deliver for the operators and what have you. And we're always extremely appreciative of the amount of support that we get from MinterEllison across all areas. Every year, again, Minter's session is one of the most highly rated of the Leaders Summit. And to the three partners it's now three partners who are going to present to us today, they do put a lot of effort into this presentation, and I'm sure you're going to find it really worthwhile. So we have Penelope Eden, Deanna McMaster and Tammy Berghofer, who are going to join us and review retirement villages, aged care and workforce. And if I could invite them to the stage. Thank you.
Good morning. I promise I'm not doing a Kanye and Crashing Taylor. I'm a bit of a last-minute pull-in today, but thank you to DCM for having us here. Every time Penny, Deanna and I are asked to return, we wonder if you're really enjoying our content, or when we get off stage you have a little chuckle about how we try to make regulation interesting. Either way, we don't mind. We're pleased to be part of this important conversation once again with DCM and all of you. So what's on the agenda today? Why are there three of us up here? What we're going to do today, my little clicker, is I will start with a bit of around the grounds on the retirement villages front. I was up a couple of years ago and there was quite a bit of red on this slide. Things have progressed a little bit, so I'll be working through that. I'll then hand over to Penny. Penny is a partner in our aged care team. I work very closely with Penny, and she will also do a bit of a snapshot of the aged care regulatory reforms. And then we have Deanna from a workplace perspective. So Penny and Deanna are going to explore the connections between statutory duties in aged care and the workplace legislation, which is an increasingly relevant topic. Finally, what we're hoping to do is make it a little more interesting and have a real life scenario. And that scenario is going to cover the transition from independent retirement living to permanent aged care. And it's a journey that all of us will need to navigate at some point in our careers or our personal lives, and the landscape is constantly evolving. So we're hoping that's a really interesting session that gives you some insights into the types of issues that we're thinking about when we're working with our clients. So what is happening on the retirement village regulatory front? So as I said, it's been a couple of years since I've presented on this particular slide. In 2022, this slide had a lot of red with the traffic lights. The traffic lights represent, I guess, compliance and regulatory certainty. What we're seeing now is a lot more amber. So that's thanks to the passage of a number of bills, particularly in the past 12 months. And the good news is that we're moving closer and closer to green. Hopefully, Chris, this time next year, we'll have a slide up that's all green and you can call it Optimism Mark III. I'm looking forward to that one. The current status for a number of states is amber because while the amending legislation has gone through the parliamentary process, we're now waiting on regulations. So if you're familiar with the retirement villages legislation, it's very heavily reliant on regulations, which is subordinate legislation that fleshes out the actual legislation. And it usually has a lot of the detail about what your disclosure documents include, what financial obligations you have for disclosure to residents, that sort of thing. If we look at Queensland, we're now in stage 3 of a 3-stage reform process. I like to call the current situation we're in Queensland as tranche 1 of stage 3. What we've seen is that the regulations have started around financial budgets and reporting. So Queensland has a really complex disclosure regime when it comes to preparing budgets and then doing your financial statements at the end of the financial year. The feedback from a lot of our operator clients, particularly those who compliant in all respects, but now need to work through some complex systems that are designed to work across the whole country, is to try and tailor the information that's required to make it compliant with the Queensland obligations, which all feedback is that necessitates additional manpower, and that comes at a cost. And the question is, how do we pass that cost on to residents or make it viable? So the key point to take away from Queensland is we're still very much focused on transparency and accountability and disclosure of information to residents. And we're just waiting now for tranche 2 of stage 3, and then hopefully we're sitting on a nice green light there. For New South Wales, the current regulations are due to expire on the 1st of September this year. That means that new regulations will come into place. And there's currently a consultation draft out for the new regulations. The main change, if you've been grappling with asset management plans, is that there will be amendments to that. The feedback has been heard by the department that they are complex and they're not giving residents the information they really need. There's a lot of irrelevant information there. So there will be a winding back to some extent on the asset management plan requirements. There's also a focus on the dispute resolution process. So I think if you've been through a retirement village dispute, you know it's long and arduous and no one comes out happy. So the feedback through a lot of the different states and the focus for a lot of the regulators is around the dispute resolution pathways and how we can produce better outcomes where disputes are resolved in an amicable fashion and everyone can continue on without that tribunal animosity that comes about through that process. So it's very much watch that space. Now, I don't have the ACT on here and I'm very sorry. It was remiss of me. We love the ACT. The ACT is also amber right now. We've had some changes to the Act as well as the regulations. So that is very much around, they're not significant changes, but there is a requirement now to develop and administer a prevention of elder abuse strategy. So a lot of operators will need to navigate that if you have villages in the ACT. Now, I love Daniel's reference to the Victorian legislation yesterday. For us, if you're not aware, there's some very significant reforms coming down the pipeline in Victoria. For us, that is one big red LED light. It's quite substantial. From a Queensland retirement village specialist perspective, the changes in Victoria aren't too much different to the Queensland legislation, so we're quite used to navigating what these new proposed requirements are. But for those in Victoria, it's a very significant change. So watch the space on the Victorian front. Some of the particular changes, if you're not aware, are around limitations on how the exit fee is calculated and when. That is deeply concerning because we need flexibility in our models to be able to accommodate different types of financial circumstances. So legislation impinging on your ability or the way you calculate the exit fee, I personally think is regulation overreach, but we'll see how that goes through the process. There's also 12-month buybacks proposed, new disclosure documents. So we'll all be digging out our disclosure documents and redoing them. And interestingly, an obligation to publish the disclosure documents on the website, which I'll touch on shortly. Lastly, if we keep on heading west, we've got South Australia and WA. So both have had amending legislation that came through late last year, both long awaited, in some cases with WA quite a long time. We've been waiting for those changes. They are in a situation, they are orange because we're waiting for the regulations to come through. The changes that are coming in those states include increased requirements for the content of residence contracts. So both states were quite pithy on the detail about what you put in a residence contract, and the regulator is cracking down on that. Changes to your ability to increase recurrent charges or service charges, 12-month buybacks, and a particular requirement about training staff and dispute resolution. So that's becoming a bit of a theme through the reforms. And lastly, in Tasmania, a nice green light, nothing happening that's substantial right now, so a safe space in Tassie. So when we look at all of the consultation reports and the impact statements and read through all the explanatory material, there's 3 key themes that are coming out of these reforms. The first, and I don't think this is a surprise, is transparency and disclosure. So residents want more information. They want to understand what they're paying for, the process of moving in, living in and leaving a village. They want the information to be concise and accessible. I think that's why there's a theme for these disclosure documents to be available on the website. Prospective residents want to be able to compare apples to apples. And so having it on the website means that that's actually probably their first point of contact or information they get about your village. So by having the disclosure information on the website, they can shop across multiple different villages, get that information and make a decision about who they're going to approach. This is before anyone in your sales and marketing team even gets involved. So this highlights the importance of having really great disclosure documents that are clear and that are accurate on your website. And if you make a change, making sure you're updating what's on your website, which is a bit of a process. Queensland went through it and it was 6 to 12 months before it became a habit, before operators understood whose job it was to replace the disclosure document on the website. And our regulator was very much onto it and was following up operators for not complying. So something for Victoria and other states that are now requiring that to keep in mind. The next theme is governance and resident rights. So we're seeing a rights-based regulatory approach. Retirement villages legislation comes in all different forms. Some is accommodation legislation, so it doesn't look at consumer rights. Others are very much consumer protection legislation. The theme with all of the changes is we're moving towards wholesale consumer protections. So approaches about dignity, autonomy, and services and the access to services are at the forefront of the regulators' minds. This ties in with codes of conduct and behavioural standards that pretty much every state has or will shortly have, because operators, the key feedback that the regulators are receiving is that on-the-ground training just isn't there. And I take my hat off to Chris Baines and the DCM Institute. They have an absolutely incredible training program for village professionals. And unfortunately, the regulators have jumped on it and that isn't recognised. I'd love to see a world where that professional training program is recognised by the regulators. And we also need to recognise that this whole process of exit is still a really hot topic. So I look at this as resident expectation management. I'm not sure in the past we've been so great at managing resident expectations about moving into, living in, and particularly leaving a village. So the resale process, the timeframes to pay the exit entitlement, that's a very clear theme coming through in the reforms, is that residents have been concerned about this, it's resulted in disputes, and the regulator is cracking down on it. So I'm putting my optimist hat on. For those in the room that are operating in just one state and are really feeling the challenges, please take heart. Every state has felt the pain or is currently feeling the pain, so you're not on your own. But the good news is that we're actually likely to see the last tranche of significant regulation come through in the next 12 to 18 months. And as I said before, I'm hoping at that point we'll have a lot of green on our traffic light system. As Tom and Daniel highlighted in yesterday's session, this is our opportunity, once we have a lot of green and the regulatory environment has settled a little bit, to really shift our focus to forward thinking. We know the environment we're operating in. There's no unknown changes coming through, curveballs being thrown out, and we can actually define a clear plan for the future and allowing the sector to do what it does best, which is innovate. And as we shape that future, we have a really valuable opportunity to learn from the past. Care in the village is evolving. If you've been here for all the sessions, that is very, very clear, and I 100% agree. With that in mind, we need to be conscious of what has driven this wave of reform and how can we ensure that future changes are proactive rather than reactive. Reflecting on my experiences, I see two key areas that have shaped where we are at today. The first is a really strong focus on residents and customers. So what do they want? The transparency and accountability piece. We've obviously fallen short there. So the regulator has had to step in and try and rectify that. Can we, as care evolves in communities, be more proactive in that and think of the past learnings to address the future sector and the regulation front? The second is, as I mentioned before, managing resident expectations. So we now have disclosure documents that are an amazing talking point for a prospective resident coming into a village. They let your staff work through the costs, the services, the facilities, so that their expectations can be managed, their questions can be answered, and they come into the village being fully aware of what it is they're entering into. I think we can all accept that the recent media attention is around, in particular, smoking, that missed opportunity to really define what it means to live in a retirement village and that you're in a community. It's not a sole, for want of a better term, selfish living option. So we've made significant progress in a very short period of time. Past 5 years, even in my role, I've seen substantial compliance focus. It's very much that operators now have a compliance-based business model where residents are at the centre of their decision making. It's moving into care and making sure that remains the case. So before we do our deep dive into the practical application of all of this, I'll hand over to Penny to walk through the aged care reforms. Thank you.
Thanks, Tammy. Thanks for the opportunity to join you today at what is probably a really significant inflection point for the aged care sector. There certainly is a lot for us to talk through. I will try and keep it light, but you know us lawyers, we love the detail. So look, what I'm going to do today is I'm going to spend a few minutes looking back just to really contextualise where we're going for the forward journey. So as you are all well aware, we've certainly heard yesterday about a number of the reforms from the Royal Commission. A number have already been implemented. Changes to board composition requirements, for example, strengthened governance obligations and new codes of conduct. We've got care minute obligations in residential aged care and obligations requiring 24/7 RNs. We've got a new single assessment system, making it much more seamless and easier for consumers coming in and entering the system. We've got new star ratings, new quality performance indicators, a lot of new. We've also got, thankfully, increased wages for our workers at the heart of what we are doing in aged care, delivering quality services. There's also, as you will all know very well, a number of increased data collection and reporting obligations. Think the QFR, the quarterly financial reports, the governing body statements with your annual attestation. And while the Royal Commission responded to many of the key fundamental issues that underpin quality and safety, there was a major gap missing, of course, in relation to financial viability for the sector that was already really struggling. And that was the work, as we heard yesterday, that was the work of the Aged Care Task Force. They delivered their report in March last year, and I'm not proposing to traverse the minutiae or the detail of the task force recommendations. That's much better left to the wise minds of Cam Ansell and Grant Corduroy. I did want to make a couple of key observations. One of the key recommendations that was made by the task force was that government should maintain its role as principal funder of aged care, with consumers contributing where they're able to do so, to things that they've always contributed towards, costs of their accommodation and their everyday living expenses. And I think we can thank the work of Chris Baines and the DCM team for their advocacy around some of that work as well. And we are now seeing these translated into the legislation. We've got changes to means testing arrangements that will see, as Cam said yesterday, a separation in the clinical and the non-clinical components of service delivery. And this really seeks to align to models that we have in the UK and in New Zealand. And as Cam noted yesterday, it'll enable government to turn the dial on individual contributions as the cost and the demand for aged care services continues to rise. And we've heard those demographics yesterday. In what I think is a win for RAC operators, they're no longer required to obtain approval from the pricing authority to charge accommodation deposits up to $750,000. And then they're also permitted to retain 2% of RADs for up to 5 years. I think that might be changing over time as well. Other reforms, the removal of ACAR and the new places to people concept or policy regarding the allocation of residential aged care places, the commencement of the health on the shelf, the higher everyday living fee, and the new strengthened standards all coming in from 1 July. So 1 July is a really critical time for the sector. The government's renewed focus on home care has also meant a proportional reduction in the spend on residential services. And that brings with it, I think, both challenges but also opportunities, particularly for retirement living operators and those operating in seniors living. And we've certainly heard a lot about that already. The new Act commences, as you know, 1 July, and it will implement the remaining recommendations of the work of the Royal Commission. And as you know, it really shifts the focus from providers and the receipt of subsidies to consumers at the centre. And that's really been something I've just heard in every presentation yesterday and again this morning. It really focuses on human rights at the centre, those receiving services. The rules that accompany the Act are still being released, slightly unhelpfully, being drip-fed to us. They're being consulted on as well, which is helpful. We've certainly seen a lot of advocacy through the peaks in relation to those, and they will support the commencement of the Act. There's also a federal election to be scheduled in there as well. So there is quite a few full stops along the way. It's a daunting task. There's a lot to do, and it does make timing and implementation for you as providers tricky. There's a lot of moving parts. But despite that, I am an optimist. I am a glass half full kind of a person. And I do see a lot of opportunity once the regulatory settings and the architecture is set in place for us as operators across the seniors living sector. So the question really is, well, how do we do this and what does this look like? And as your lawyers, our job is to take you through the regulatory settings and to try and simplify things for you as best we can. So the new Act, as I said, it's a human rights-based legislative framework. It focuses on the health, wellbeing and the safety of those in our care. And it's structured in a way to give effect to the human rights conventions that form part of the Act. And this is really exemplified, I think, by the inclusion of the Statement of Rights right up front at the beginning of the Act. And that tells us what our clients should expect to receive in receiving funded services. The new Act also imposes a range of obligations on you as providers, and this will be a condition of registration. It's really important to understand that. The conditions will vary between providers, dependent upon your registration category, but there will be certain conditions imposed on all registered providers, regardless of registration category. So a condition of registration will be that providers are required to understand the Statement of Rights, not just what they say, but how you are to operationalise them, and to ensure that the way you deliver services is compatible with those rights. Operating alongside the Statement of Rights is a statement of principles, and that's intended to guide the decisions, the actions and behaviours of us as providers, but also other key stakeholders like the Commission, the Aged Care Quality and Safety Commission, the regulator, and also the Department of Health and Aged Care. The Act also contains a definition of high quality care, not a duty, a definition. And that is intended to guide service delivery. It's an aspirational goal. It puts the individual first, consistent with the human rights approach, and it prioritises a range of holistic factors, things like kindness, compassion, respect, timeliness. As I said, there's no positive duty to deliver high quality care, but you will be required to demonstrate your commitment for and capacity towards the delivery of high quality care. So against these conditions of registration, we have a broadened regulatory powered commission and a new regulatory strategy as well. The Commission has a range of expanded powers and the ability to use a range of regulatory levers, including suspending or revoking registration, issuing banning orders, issuing notices of required action and applying civil penalties or fines, which we'll talk about shortly. The Commission's regulatory strategy, it's published, absolutely commend it to you. It emphasises what they term a proportionate and risk-based approach to non-compliance, and it focuses on monitoring and investigation in specific target areas where there is the highest risk of harm or where there are serious or systemic issues. So you might be aware that one of those target areas currently is care minute compliance. The Commission is scrutinising all the data. It's collecting a whole lot more data than we've ever collected in aged care, looking at CSRS reports, accreditation outcomes, complaints data, triangulating all of the information to understand and proactively intervene in areas of emerging risk. So it's really critical, as I say, that you're aware of these. It's not intended to be a stop sign for you. It's really intended to bring you the awareness that you need in order to ensure that the work you are doing can be done without an increase to the compliance burden. The Act introduces this new universal system of registration, which I've just sort of touched on, and it will see providers grouped into one or more registration categories based upon the characteristics, the risks, and the provider's individual obligations. So while you might be registered in multiple categories, you will only hold one registration. But importantly, you will be required to re-register every 3 years. That is new for the sector. And in that, you'll be required to demonstrate your ongoing suitability, your capability and your viability, and your compliance with your registration obligations. As you'll see from this slide, I've tried to really map across the categories, the services and the standards, just to give you a sense of how they will all intersect. Your registration category will determine the standards that will apply to you, and unsurprisingly, all of the standards will apply to Category 6 providers, which is the residential aged care category. There'll also be a consolidation of the existing 4 prudential standards. We now have 3, the liquidity standard, the financial and prudential management standard, and the investment standard. And the new standard will also incorporate certain categories of home care providers for the first time. The new standards require certain providers to implement a financial and prudential system to ensure financial viability, to monitor and control delegations, outsourcing roles and accountability, and to implement effective reporting mechanisms to control finances, and also to oversight the management, use and refunding of deposited amounts, accommodation amounts. The new liquidity standard and investment standard are only expected, at least on the current drafting, to apply to Category 6 providers, residential aged care. We've heard a lot about the liquidity standard, and I appreciate and have heard the concerns from providers. Based on the current drafting, my view is the liquidity standard will require providers to hold a minimum liquidity amount of at least 35% of cash expenses for the previous quarter, 10% of refundable deposits, so RADs, and 10% of refundable independent living payment amounts, which is yet to be defined, but clearly incorporates retirement living providers in there as well. That, of course, is a great concern, not only in terms of the overreach. I got to use the word ultra vires as a lawyer for the first time quite recently. That was exciting. But also in terms of, importantly, in terms of the impact to the ability of providers to invest in redevelopment. Consultation for those standards closed last Friday, so we are all waiting with bated breath to see where that lands. I'm going to spend a little bit of time on supported home. The new supported home program, we've heard about it yesterday. It will amalgamate the existing home care package program, the short-term restorative care program, but CHSP, the Commonwealth Home Support Program, the low entry-level program, is not slated at this stage to come online with supported home until July 27. So in line, I think, with government policy objectives and, of course, the expectation and demands of the baby boomers, demand for home care is steeply increasing and will continue, I think, to increase, not just in the delivery of aged care services, but I think across the human services continuum. So we're seeing a big investment, financial investment, but I heard yesterday from Grant Corduroy about the waiting list, the dire state of the waiting list. I have parents waiting for packages myself. So it is a continued pressure, not just for those waiting to receive services, but for you as providers as well. So the current drafting says that existing home care package and STRC short-term restorative care clients will automatically transition to supported home into whatever category of funding they are receiving, which will be known as their classification. New entrants will be required to undergo assessment through the new single assessment system. There will be 8 new classifications. I've put those up there on the slide for you, with increased funding up to about $78,000 a year, which is proposed to be indexed annually. I see a lot of David Tune in a lot of these reforms, which is very welcoming. Package management, will be scrapped. Care management fees will be capped at 10%, and this can be pulled by the provider across your entire service stream. Service lists will be published, so a bit like what we've got in NDIS. There'll be some new inclusions around therapeutic services, telehealth and assistive technology. But as I said, there will be caps. That is yet to be published, so we have a bit of unknown around that. Margins, I anticipate, will be further squeezed, with government only fully funding clinical supports and participants being required to contribute It's on a sliding scale. So for independence supports, between 5 and 50%, and for everyday living supports, between 17.5% and 80%. And that'll be based on the aged pension test. Existing participants that are under the existing current home care program will maintain their same level of funding. They'll come across with the same level of funding under a no worse off principle. We are yet to see the grandparenting arrangements. Again, we're waiting with bated breath for those, but I heard on Friday that there is an expectation that existing HCP clients will all need to have new home care agreements. Wow. Support at Home will also introduce 2 short-term care pathways, the restorative care pathway and the end-of-life care pathway. So again, some terrific opportunities to support clients in care hubs, in an RV setting, for example, returning from hospital or palliating in your village. There'll also be assistive technology and home modification scheme for those who are eligible. So as you can see, there is a focus on early intervention, reablement and assistive technology, which is really pleasing. The department has released a number of guidance documents. I have read all of them. There's a lot. The Support at Home handbook, the transition guide and the program manual, very helpful practical guidance for you. And just thought I'd read this out to you. The transition guide says that to successfully transition your organisation, you'll need to review and update your financial and reporting processes, assess the impact on the business and operational models, prepare your ICT systems, update communication protocols, look at your workplace training, etc. I know the challenge, of course, is there is a lot of detail still yet to emerge, but certainly there is a lot of work for us to be doing. I'm just going to move now to talk you through quickly at a high level the new statutory duties. They exist now in the Aged Care Act and will come into play, as I said, on the 1st of July. There are 2 duties that you will need to be aware of. The first is the registered provider duty. The second is the responsible person duty. Now, these have been modelled on the Work Health and Safety Act, hence why Deanna is here with us today. Deanna and I have been working really closely to understand not only how the duty will impact, but how it will operationalise and what are the sort of things that you need to be thinking about as providers to ensure you're able to discharge the obligations that you have. So under the registered provider duty, this is the overarching statutory duty to ensure, so far as reasonably practicable, that your conduct does not cause adverse effects to the health and safety of individuals to whom you are delivering funded aged care services. So the Act broadly mirrors the Work Health and Safety definition of reasonably practicable, and to that end, I'm going to ask Deanna to come up and talk to you about what that looks like.
Thanks, Penny, and hi, everyone. Last year, I spoke to you about the learning we can take from the safety framework in understanding the new Aged Care Act duties, and thankfully, there remains significant overlap, so we can take a lot of insights from some laws we've had for over a decade in the safety space as to what it might look like in the aged care sector. To put it into practice, as you'd all know, and duties you all have already, under the work health and safety regimes, we all owe a duty to ensure the safety, so far as is reasonably practicable, of workers and others, including those we provide care to, but also members of the public, family members, and so on. As Penny mentioned, under the Aged Care Act, we will now, from 1 July, also have the duty to ensure, so far as is reasonably practicable, the safety of those that we are providing funded care to. The fact is that the standard that must be reached now looks the same. This means often the same steps are required under the aged care regime and the safety regime. Lawyers don't say this much, but this genuinely is cause for optimism. Finally, we're getting some sense and alignment across statutory regimes. The other benefit, because of this alignment, is we can look to what's been happening in courts and tribunals for a long time to understand what our job is in aged care. What we absolutely know is ensuring safety, no matter who it is, so far as is reasonably practicable, is not absolute. It doesn't mean doing everything that is possible. What it does mean is something narrower than that. It needs us to balance risk, And we're really used to doing this, particularly as executives and boards across all seniors living organisations from a safety perspective. When you look at it from an aged care perspective, it requires exactly the same job. What we're doing is balancing the severity of an injury and the likelihood of injury against the availability and suitability of control measures and cost. The bit that's a little bit different for aged care is that we also need to have regard to the dignity of risk. This was something that was emphasised when the Act was passed in some late amendments. The point here, of course, is that dignity of risk is something that is the centre of person-centred care, and our older people need to have a say in terms of what is reasonably practicable. I understand that as a concept, but it is going to be interesting to see what happens in practice as to how that's applied, given we've seen how strict courts take the balancing of risks already in other regimes. The bit that I have to say, because I'm a lawyer, is whenever you are applying a reasonably practicability test, please document it if it's a big decision for your organisation. We know that all regulators and courts don't believe things happen unless we can show them some paperwork. So I think you've got a bit of time ahead of 1 July, and it's worth getting ready to do that now. Oh, no.
Yeah. Thanks, Deanna. The second duty we're going to talk you through is the responsible person duty. This is a separate duty to exercise due diligence to ensure that the provider, the overarching duty, is complied with. The term responsible persons really replicates the term key personnel. So that means the duty will apply to people responsible for making executive decisions for the organisation and any other person with authority, responsibility or significant influence over the planning, directing or controlling of the activities of the provider, the board. You might recall I spoke last year about the significant concern that existed in response to these duties, which were then drafted as being offences of strict liability, meaning fault was irrelevant. They also extended to middle management, people like RNs and facility managers, and carried with them the threat of criminal sanctions. So these were serious business and continue to be serious business. But under the new Act, neither of the two duties will operate as on a strict liability basis. So it's an exhale moment for us, which means that there will be a requirement to do a weighing. So looking at the relevant facts and circumstances when we're looking to determine whether there has been a breach. The new Act has also confirmed that the scope of the duties will be carved out, as I said, so people working in day-to-day operational roles like facility managers, for example, registered nurses will be carved out of this duty, which is an excellent outcome after a lot of advocacy. So the scope of the duty is only intended to capture those persons who hold critical roles and have the ability to influence the culture and accountability of the provider. Now, responsible persons can be held liable for failing to exercise due diligence even where the overarching provider duty has not been breached, but the converse is not true. And this replicates the duty of officers in the work health and safety legislation to exercise due diligence. So what's considered reasonable? Such a lawyer thing to say, but it will depend on all the circumstances. Helpfully, though, the Act does give us some guidance around this. So it includes things like acquiring and maintaining up-to-date knowledge about contemporary practice, what your peers are doing, understanding the potential adverse effects that exist in the delivery of funded services. So really engaging with the data and information that you're collecting, looking for trends, ensuring you've got appropriate resources available and that they are being used appropriately to manage risk, receiving and responding to information about incidents and complaints and risk, establishing and maintaining and verifying your compliance processes, making sure they remain fit for purpose. Deanna, I might invite you back to talk about what we can learn from the work health and safety context in relation to the exercise of due diligence.
Thanks, Penny. Like reasonably practicable, we really have also picked up due diligence from the safety regime. The safety regime has really, over the years, focused in on what executives and boards are doing personally in terms of due diligence. We think that that's probably what it will end up looking like in aged care as well. If you take one thing away today, if you're an executive or board member, it's that this is a checking job, not a doing job. Increasingly in the safety space, the cases that don't go well for executives in particular are where they take on doing the job as part of their duty. It really is just keeping an eye on what others are doing. Unlike last time I spoke to you, we've now started to have a lot of decisions come out of the courts in the safety space that's going to really help us understand in an aged care context what we have to do. The first message is it's not safety or care as imagined, it is safety or care as it is happening. So executives or board members who adopt an approach of wishful thinking are going to find it really difficult to discharge due diligence. You do have to ask hard questions, and you do occasionally have to insist that better reporting be provided or that your management teams give you a deeper dive on particular issues. We know that from a pretty awful New Zealand decision just a couple of months ago where the CEO of Auckland Ports was found to be guilty of a breach of due diligence. The other positive, though, that we're getting out of the safety decisions is that it's actually okay to rely on experts when you're a board or executive or other responsible person. But if you do that, make sure they're the right kind of expert and that you check in with them from time to time. And that was actually the defence used by the managing director of the Cairns Zip Lines organisation when they were charged after a fatal accident a couple of years ago. The other thing we know is it actually depends on the role and influence you've got in the organisation as to what reasonable steps to take due diligence looks like for you. Naturally, boards are a further step removed and should act consistent with that. The other message we get loud and clear from safety is site visits from time to time are essential. Not every site, not every week, but please don't do due diligence as a desktop role. It gets really difficult to defend any allegation that it hasn't occurred. And then the final piece, I think, particularly relevant in aged care, is the job as a board or an executive with a responsible person duty is to close the loop. If you get some reporting and something doesn't look right and you ask a question, please make sure people come back to you to close that out for you. In the safety space, we increasingly have decisions, particularly where poor executives are held responsible for not exercising due diligence because they haven't gone back and insisted on an answer to the question they've raised. It is a positive duty and a proactive one. In terms of the practical piece about due diligence, exercising it's one issue, the other is trying to prove it. So what I think anyone who is a responsible person between now and July needs to start doing is sort of getting those hygiene pieces in place. What will the minutes of meetings look like where you do discuss or exercise due diligence? Who will run the action lists of queries if you don't already do that you raise as responsible persons? How will you make sure you get around to a decent representative group of sites? And should you take some standard questions with you when you go out to Iraq, for example? And finally, please get proud of the due diligence reporting you receive. If it's anything like the safety experience, we will have to start handing it over to third parties who will look at it with lots of scrutiny at some point. I think the other thing we really have to embrace now that we're talking about due diligence in this sector as well is we just have to be receptive to board challenge. We do have to welcome robust discussions about issues. We don't walk away from something because it might be a bit sensitive or be a bit upsetting to a particular individual. Due diligence is asking the question that no one else is asking and the minutes reflecting that a discussion occurred about that at a particular meeting. I think the real key point, if I can before I will hand back to Penny, is such a learning from the safety space is you need to get the reporting that you receive as responsible persons the very best it can be. Please have it focus on systemic issues. Don't have it be War and Peace, reams of paper with just data. It needs to take you to trend information, give you some insights, and enable you to do that real testing and questioning. The role of a responsible person is to look at reporting and say, what is this information telling me? What's the story behind it? And do we have a broader cultural issue that I need to look into? We get asked a lot about what should the due diligence report look like, and we've been working on, I guess, a bit of an ingredient list back at Minters. I don't think it should ever be too long, which I've already mentioned, but I think there is time between now and July to make sure you get a really fit for purpose report that goes to executives and boards on a regular basis. Lawyers would love that to happen at least monthly, but I don't necessarily always live in the real world. If you aren't doing all these things, this isn't anything to be too concerned about. It sounds like it, but there is a practical way to work through it by just asking good questions.
Yeah, so our optimism is trying to make life easier for you in terms of, as Deanna said, things like due diligence checklists, making it part of everyday practice, getting the architecture and the structures in place. I'm going to quickly, in the time that we have left, run you through the civil penalty provisions. But just before I do that, just to say the other key change between the exposure draft and the Act now was the removal of criminal sanctions. Great exhale moment for all in the sector. Now, in terms of looking at the civil penalty provisions, as I said, these are fines. I've tried to, as best as I can, up on the slide, give you a sense of a bit of a flow chart of how this will work in practice. So as you can see, there are a number of requirements to be met before a breach can be established. So where a registered provider engages in conduct without reasonable excuse, there's the reasonableness there, the weighing exercise, which causes adverse effects to the health, safety, and well-being of an individual to whom the provider is delivering funded aged care, so registered provider, funded aged care, there will be a liability to a civil penalty or a fine. If the conduct exposes the individual to a serious injury or illness, and it involves either a significant failure or is a part of a systemic pattern of conduct, it will constitute a serious failure, meaning that there would be a failure to comply with the duty and you'll be liable to fines. So the provider might face a penalty here of upwards of around $300,000, just to give you a sense of what these fines sound in. And if the conduct results in the death, serious injury or illness of the individual in your care, fines can be upwards of $1 million. So there's a good question for you to all be having with your insurer about coverage. There'll be different financial penalties where the person contravenes the responsible person duty. They are sort of much lower. But look, it's serious business. So as I said, I've tried to simplify. The legislation's quite complex here. I've tried to simplify it on the screen as best we can. The other thing I wanted to say, I've gone over time, I'm in the red, as always. The new Act is focused on concepts of restorative justice, and there is a new compensation pathway. The information, as we know currently, is limited. There's still a lot of detail missing. But where the provider engages in conduct which constitutes a serious failure or results in serious injury or illness to an individual to whom you're delivering funded care services, either the commission or the individual, the harmed individual themselves, may apply to court for a compensation amount. As I said, the detail is yet to be made available. The other key feature to say here is that because these are statutory duties, the limitation period is 6 years, which is different to what we currently have in the common law context of a personal injury action, which is 3 years. Chris, we have gone over. We do have a case study to bring it all to light. I'm concerned that Gerald's going to have to stay in the village and he can't come out to join us today. But look, if there's any questions, perhaps we might take those quickly if there's time. In your hands. Thank you. In your hands. What? Yeah, questions perhaps.
How long is it? Okay. Well, can we ask, are there any questions? Thank you very much, firstly.
Gerald?
I know the case study will be fascinating, but we don't really have the time. But are there any questions from the panel? There's so much covered there, but are there any questions? No? Yes. Andrew. So we've been asked to cover the Auckland City Ports matter where the CEO got prosecuted.
Yes, it's actually pretty scary, I think. And the reason it's relevant is the New Zealand framework actually reflects the Australian framework by and large. I actually think the CEO, in his defence, was doing a really great job at getting out and about among the business. But I think I didn't act for him, so I can say this. I think probably he did engage in a bit of wishful thinking, as I said. So he was being told things were happening. He was quite happy to imagine that that is exactly what was happening without getting reports and testing why trends were going in certain directions. So I think in an aged care context, if something doesn't look right, we do have to raise it, and minutes of meetings should show we do that. And if we don't get out and about and see what the actual operational risks and hazards are, we just can't exercise due diligence. We're actually doing a case note on it, which maybe we can share, because it is such an odd, it's really the first large organisation that's had a CEO charged with a breach of due diligence, which is why we're all watching so closely.
Okay, thank you very much. Perhaps would it be possible for two things? Firstly, would you be able to provide a brief note on Auckland? And secondly, would we be able to produce your case study, because I know it'll be excellent, that we might be able to distribute? Okay. Thank you very much. Can we show our appreciation?